All right, 11 to 5. You guys ready to go?
We are.
Okay, guys. So, to all our attendees, good morning. Welcome to our SB-91 webinar. Allow me to introduce myself. My name is Justin Wong. I'm the president of the ARIA Greater East Bay Chapter. What is ARIA? ARIA is the Asian Real Estate Association of America, and we cover the Alameda County, the Contra Costa County, to represent the Greater East Bay Chapter. As an organization, we have 17,000 members, 41 chapters, and this event wouldn't be possible without our sponsors. So a big shout out to our diamond sponsor in Bank of America and our emerald sponsors in Wells Fargo, HSBC, Union Bank, Bank of the West, Chase Bank, and Citibank. And I also want to give a shout out to our committee for making this this event happen, in Margaret Lin, Keith Asuzawa, Sin Trung, and Vivian Ho. I'll go ahead, since it's a collaborated event with a couple of other awesome organizations, I'm going to go ahead and introduce Mark Kim with ACP.
All right. Hey, good morning, everyone. My name is Mark Kim. I am the president of Asian Commercial Professionals. Great to meet you all. For those of you who do not know, Asian Commercial Professionals, ACP, is a local nonprofit. What we do is we are an organization that supports Asian Americans within the commercial real estate industry, whether you're in commercial real estate, construction, facilities, design and architecture. This is a group that we have started to support and create some future leaders in our industry. We provide programs that include for education, some networking events, and a big thing, which I'm really most proud of, is that we give out scholarships every year to students and also working professionals. So big thanks to Justin for allowing us to collaborate for this exciting program. Looking forward to meeting you all eventually in person, and excited to see how things are opening up. One final thing I'll leave with you all is that we started an initiative called Amplify Asian Voices, and kind of part of it is related to the Asian Awareness Month, but also to kind of bring some a spotlight to Asian American leaders in our industry. So I'll drop the link in the message here for you all to take a look at it. We're doing some fundraising, do some exciting programs. So drop that in there for you all to take a look. And with that, I will leave you and pass it on to Eric. Thanks.
All right, thank you, Mark. Good morning, everyone. My name is Eric Rellos, and I've got a couple of roles here. First of all, I am the commercial chair for ARIA Greater East Bay Chapter, but I'm also the president for FARIPA, which stands for the Filipino American Real Estate Professional Association Bay Area Chapter. With FARIPA, we represent or we cater to the needs of the Filipino American community when it comes to residential real estate by providing different events and educational events like this webinar on SB-91. I would like to thank Greater East Bay's marketing team, Keith and Zen, for putting together the marketing flyer for this, and also Dorothy and Maggie with FARIPA for helping out with the marketing flyer for that membership. At this time, I want to go over the goal of the webinar. Basically, it's to educate our listeners and their investor clients on the COVID-19 Tenant Relief Act, or SB-91, which was signed into law on January 29th, 2021. Basically, it's comprised of two parts, first being the state rental assistance program, and then the eviction moratorium, which our speaker will cover. At this time, I'd like to review our Q&A rules. So we're going to be allocating time at the end of the presentation for the speaker to answer questions for the attendees. So please use the Q&A button at the bottom of the screen to send your questions, which we will compile for the speaker to answer. So at this time, it is my pleasure to introduce our speaker. We're very excited to have Daniel Bornstein as our speaker. Daniel is the founding attorney of Bornstein Law and is a well-respected authority in landlord-tenant issues, disputes, and property management issues. So Daniel has over 26 years of experience in handling real estate and civil litigation throughout the Bay Area. In addition, he also manages rental property and is instrumental in completing real estate transactions and well known for his educational webinars. So a lot of the attendees were already familiar with Daniel. So in summary, Daniel is the ideal speaker for this webinar as he shares his insight as an attorney, an investor, and property manager in educating us on SB-91. At this point, I'd like to introduce Daniel Bornstein.
Thank you very much, Eric. And it's my pleasure to be invited to your organization to give a seminar. And my hope is that if people are engaged and stay focused, they'll get a better understanding of this very complex law and be in a better position to educate their clients or themselves about how we handle this pandemic successfully as real estate professionals.
All right, let me go ahead and get started with the slide, okay, Daniel?
Absolutely.
All right, let's go. Let's see right here. There we go. All right, so are we good to go?
We are good to go. So first of all, I want to say to all the attendants, you should congratulate yourself for making a decision to participate in this. I admittedly am in a position to understand the law in a better way than many other people, but getting a sense of all of the nuances of the law is very, very difficult and cumbersome. If you talk to 10 attorneys, maybe one of them will have a working understanding of the law. And so you're in a good position to educate yourself. And if you just stay focused for about 35, 40 minutes, you'll get an understanding of the total of this law and how you can successfully migrate it and participate in some of the programs that are available to landlords, property owners, and investors. So with that stated, why don't we move to the next page? The agenda for my talk will be first an introduction to SB-91, an assessment of how and under what circumstances you can participate in the state rent relief program, and then some other nuances as it relates to rules regarding SB-91 in relation to your landlord-tenant matters and how this new law impacts the ability to recover possession during this period of time and certain moratoriums that are in effect, such that you should be educating yourself about how best to handle disputes during this very difficult time in all of our lives. And then I'll segue quickly into some of the strategies necessary to potentially recover possession of the premises without actually seeking judicial intervention. So with that, I think after we go through this protocol or this agenda, you'll be in a better position to understand the complexity. And to the extent you do have questions, of course, I'm available to answer them as they arise after the completion of this webinar. Before I commence, and I have to tell all of you this, never in my professional career have I had more new laws imposed upon us than the last 24 months. So in 2020, I was getting prepared to educate the California community about the new state law regulations of rent control and just cause eviction rules. And then what came upon us was the pandemic. So we had the introduction of state rent control, state just cause eviction rules, and then we had the pandemic. Then we had the state in Sacramento imposing new rules, local jurisdictions imposing new rules and regulations, and then we had a confluence of even more rules such as SB-91. Well, as of 2 days ago, Governor Newsom, who is of course facing a recall, has announced the plans to provide 100% of rent debt payable to landlords during a pandemic where some of this rent has gone unpaid. I mention this because the laws are changing, the policies are changing, and you have to stay informed as best as possible so you can take advantage of all the benefits that are being offered to owners during this pandemic. Now, interestingly, Governor Newsom just announced this, but the actual policies are not in place. The protocols are not in place for 100% recovery of the rent debt. So it's an announcement, it's a new policy, but it's not yet embedded in the actual protocol one could expect in order to recover 100% of the rent. And what you'll find as I go through this is that as it stands at this moment, the only amount that you could potentially recover is 80% of the rent debt. We're hopeful that with Governor Newsom's announcement, the 80% will migrate upwards to a 100% number, but it remains to be seen. So we are only in the infancy of this very exciting announcement. What it means for all of you is to stay informed by either monitoring the news, getting e-blasts from industry insiders, or staying in close contact with my office, which also provides social media updates about new laws and regulations that are occurring. So be advised, I am announcing this, but it remains to be seen how effective we're going to be able to recover 100% of the rent debt, because though Governor Newsom announced it, it's not clear how implementation is going to occur. So with that, let's start the program. AB 80 was the first state program to address the pandemic as it relates to landlord-tenant matters. SB-91 was in some respects an amendment to AB 80, which now extends the rules regarding the pandemic through June 30th, 2021. And what these rules are essentially is to preclude owners from being able to evict tenants who are not paying their rent if it's directly or indirectly related to a COVID pandemic economic concern, such as loss of job, increased expenses due to care of people, increased costs for education, anything that tangentially involves the pandemic will be a justification for a tenant not to pay 100% of the rent debt. So SB 91 that came into effect January extended protections for tenants through June 30th of 2021. And I've highlighted it in yellow, and I want to mention this. It may be extended again. We're not clear. Right now, it's through June 30th of 2021. The general rule is as follows. Tenants need only pay 25% of the monthly rent that is due in order to be protected from eviction. If a tenant has a rent debt of $1,000 a month, if they pay $250, that will insulate themselves from eviction for that remaining $750. And interestingly, the protections are as follows. A tenant who owes $1,000 in January rent debt can pay $250 of that rent debt by the end of June and be protected from eviction for that January failure to pay rent. So realistically, if you have clients who have not received rent, we're really looking at the end of June to figure out if tenants have indeed posted 25% of that rent debt. Between now and then, we're still in a holding pattern. SB 91 attempted to preempt local jurisdictions so they could not create a patchwork of new rules and regulations as it relates to local jurisdictions such as San Francisco, Berkeley, Oakland, Emeryville, or other Bay Area jurisdictions that have their own local rent rules and regulations. And then SB 91 introduced to California the state rent relief fund that is now available for landlords and tenants to seek rent relief, which is rent payment from the state to cover COVID-related rent debt. So SB 91 did two things. It insulated tenants from having to pay the full amount of their rent. It established a state rent relief fund, and it also further protected tenants from evictions throughout the state. We can turn. However, for many of you who have one eye on the news and one eye on your personal lives, you may have forgotten that there are always certain statutory responsibilities of owners in order to avail themselves of the benefits of SB-91. The first responsibility, which many people throughout the state were not aware of, is that you needed to provide all your tenants who had rent debt from March 1st through and including the present in February of their rights and regulations regarding this program. The document in front of you is what needed to be provided by February 28th, which is really a notification document, letting tenants know that if you're confronting a financial distress due to COVID, you have certain protections. It also informed tenants of this new rent assistance program from the state. And that's on the third to the last paragraph of page 2. If you have tenants who haven't paid the rent, or you have owners who haven't distributed this document, despite the fact that it should have been served by February 28, 2021, get this document out anyways. As part of participating in this webinar, if you don't have this document, just email me. I will be happy to give you this document so you can distribute it. Generally speaking, insiders in the industry stay abreast of new rules and they're able to get these documents out. The vast majority of others simply are not familiar with the law and did not get these documents out in time. It remains to be seen what the impact will be if you fail to provide the document, but always better late than never. Let's get this document out to your clients, to your tenants, get it mail served on them so that they're informed of their rights, so you're not hamstrung going forward into the future. It is absolutely unclear what the impact will be if you fail to provide these documents. This is all new law. Normally, when we have laws, we're able to look at how the court has dealt with something, because a law that is 50 years old will have a long history of interpretation. These laws are 3 months old. We don't know how the court is going to entertain it. And also importantly, though I may understand the law because this is my way of earning my professional compensation, judges aren't familiar with all of these laws themselves, because they're only going to be familiar with the law when it's presented to them. And it has not yet been presented to the courts at this time. So be advised, my strong recommendation is get this document out to your tenants. I'll be glad to provide you a template if you email me at the end of this webinar or sometime in the next couple of days, and we'll get this thing going for you. Let's move on. So the state rental assistance program. When will the assistance funds be available? In theory, they're available now. Out of the billions of dollars that have been provided to California from the federal government, at last note, a few $1 million have been distributed. So out of 1,000 million, 1 to 2 million have been distributed. So what do I mean by that? It means that in theory, the rental assistance funds are available, applications are being taken, but practically speaking, I have had no client inform me yet that they've received the funds from the state or any local government that is overseeing it. Rest assured, however, you need to apply if you have tenant-related COVID debt, because we want you to recoup those funds from the state program if possible. The Department of Housing and Community Development is overseeing this, and different jurisdictions have different locations in where you can submit the application. Can you apply to the program on your resident's behalf? The answer is yes. Landlords can apply on behalf of the tenant's behalf, but in the end, in order for the application to be complete, the tenant is going to have to also participate in the application process. I'll later in the webinar show the protocol so that you're familiar with it. And interestingly, even though it's tenant's rent debt, the money will go directly to the landlord if you have applied. Change the slide. In order for a tenant to be eligible for rental assistance, all of these criteria must be met. At least one person in the household is qualifying for unemployment benefits or has experienced a reduction in household income or additional cost or has experienced financial hardship. And at least one person in the household can demonstrate risk of experiencing homelessness, housing instability, and that can be documented through a unpaid rent notice, a past due utility bill, or such other documentation to demonstrate risk of housing instability. Generally speaking, these criteria should be relatively easy to accomplish if you have an unemployed member in the household, generally speaking. But you have to meet these criteria for a tenant to qualify for state rent relief. Next. Remember, meeting the eligibility does not guarantee rental assistance. Programs are prioritizing households that have less than 50% of the area median income, and you must be 80% under the median income to qualify. You must be under 80% of the median income to qualify. So for you landlords or property owners who have a Silicon Valley employed software engineer who's making $150,000 a month and they're still employed, but they're not paying you the rent and they claim a COVID-related impact, they're not going to qualify for the program. The threshold is 80%, and it depends upon the particular median income of that location. The most important rule was that a landlord who is participating in this program is only able to secure up to 80% of the unpaid rent debt that's accumulated from April of last year through and including March of this year. Now, remember, put an asterisk on that because Governor Newsom just announced that they're going to provide up to 100%. It remains to be seen. As it stands today, it's 80%. So if a tenant owes you from April to March $10,000, if the tenant qualifies and you participate in the program, as of today, the maximum you can recover is $8,000. The hope is that you recover $10,000 with Governor Newsom's announcement, but let's see how that plays out. Is that announcement, in fact, going to become policy, or is that announcement Governor Newsom addressing the new funding that came in from the federal government and also the need to be popular and speak to everybody in light of the recall that he is facing? We shall see. But let's keep in mind that right now it's 80% of the rent. Now, for some of you may say, well, why would I give up 20% of the rent to participate in the program? Well, because with chasing tenant debt, if you can get 80 cents on the dollar of tenant rent debt during the pandemic, it's much more efficient than hiring an attorney like me to go after a tenant who owes you money, because the cost of the attorney will be much more than the 20% loss that you may face by participating in the state rent relief program. Let's move on. What happens to the rent debt that is not paid by the state? Under the program, you give up the right to that 20% as it stands right now. And also, you are giving up the right to evict the tenant for that debt that arose. So you're not entitled to seek recovery of possession of the premises for the debt that arose from April through March if you accept participation in the state rent relief program. Do you have to accept rental relief from the state? I think you do. So if a tenant participates in the program and is eligible, and you are notified that the tenant is seeking participation, my strong suggestion is participate yourself, because if it's known that you have decided not to participate, you may be impacted negatively going forward in ever seeking to recoup those funds from the tenant if it's learned that you did not or you rejected participation in the program. If you don't participate in the program, the amount of debt that you will be entitled to recover is only 25% of the debt, not 80% of the debt. So generally speaking, for all of you, and that includes myself as a real estate investor, it includes myself as a property manager, I'm telling people participate in the state program. It's money, and it's money that could be available to you. And rather than proceeding in small claims court or pursuing an eviction action, you're much better off for this period of time trying to get those funds from the state. This is a hopefully once in a lifetime event, this terrible pandemic. We're hoping that this state program is only available once, and participate, because the consequences of not participating, I think, are going to be very negative for you. And why not try to recoup 80 cents on the dollar? Because otherwise, I think you're going to lose even more money in chasing a tenant over that debt. Let's move on. The state program also allows potentially, if funding is available, for utility arrearages to be covered as well. So where you have tenants who are failing to pay their utility bills, they may be entitled to recoup some funds to cover those utility bill unpaid amounts. Right now, there's $5.3 billion available from the federal government. Interestingly, we will only learn later how much of these funds have been distributed. The state has possession of this money, and it's taking a longer period of time than I expected to get these funds into the pockets of owners who have foregone or have been without rent payments for quite some time. If you want to learn more about the program, go to www.housing.ca.gov. That is the entry portal for the state program. It provides all the information necessary for you to educate yourself or your clientele about the program. The unfortunate issue is that the program is balkanized, meaning different jurisdictions may have different programs providing the rent relief, so that though there's a state program from some locations in the state, there are local programs that are administrating the program for instance, San Francisco, for Oakland, for Fremont. So depending upon where your property is located, you may have to go through a different protocol. But if you go to housing.ca.gov, you'll learn about it. And also later in this program, I'm going to give you some resources as well. Let's move on. So generally, and I put this chart together because a lot of people are saying, Mr. Bornstein or Daniel, how does this work? What do I need to do? Well, it can work in two different manners. Either the landlord initiates the application or the tenant initiates the application. If it's me and I'm an owner, I've already initiated the application. I go to the housing.ca.gov website, I enter into the information, and I get myself the code. I get into the system. I then notify the tenant that I'm participating in the program, and I want the tenant to participate as well. Why? It's a win-win situation. A tenant participating in the program will have their debt washed away. When is a situation going to arise where a third party, the state, is going to wash away someone's debt? Well, that's what's happening here. The first approach is you initiate the application, you provide the documentation, you get a case management team from the state to participate in helping the application through the process. If a tenant initiates the application and the landlord does not participate, then all that can occur is that the tenant household receives 25% and the landlord is without the ability to recoup 80%. And that's the orange boxes. If both the landlord and tenant completes the application and the tenant meets the criteria necessary, the landlord will receive 80% of the compensation due. Unfortunately, and this is happening, where you have a landlord who's proactive in completing the application, but the tenant is not participating, you have an incomplete application and you will not get funding. And this is happening. I'm getting calls from owners saying, I can't get my tenant to respond to me. Their head is in the sand. I don't have communication ability. They're angry with me and they'd rather spite me than participate in the program. Not much I can do. The only thing I can tell you is that if you have tenants who are wonderful people, but they have limited English skills, they don't have access to technology, they don't have computers, do yourself a favor and arrange a safe, socially distant meeting with them and help them complete the program by bringing a notebook computer to the meeting or a iPad or what have you, and help them complete the application for them. There's documents that need to be uploaded. There's applications that need to be completed. And if they're not English speakers, you can get assistance, but by being proactive, you may be in a better position to complete the program. So with that stated, this is how it's supposed to work. And unfortunately, as I mentioned previously, of the billions of dollars that's available, only a few million have been distributed thus far. Hopefully by the end of June, by the summer, the money is flowing into owners' hands because they have gotten participation from the tenant. Tenants have met the criteria and the funding is provided. And remember, as I mentioned, landlord receives 80% of the compensation. We all know from this webinar that it may be bumped up to what? 100% of the compensation. Stay tuned. Let's move on. So I mentioned that this program, even though they have a state protocol to follow, the funding have been distributed to different organizations in different locations. Where you have a large population, different organizations are distributing the funds. And so if you have tenants in Oakland, units in Alameda County, units in Fremont, units in San Francisco, you've got to recognize that there's different programs that you need to participate in. And even if you go to the state website, they're going to direct you to these locations. And unfortunately, for San Francisco, the program took a while to get started. So even though it opened up in March or opened up in April, we've got some programs that are still just in the infancy. And then each program may have different metrics. So in San Francisco, they're going to address those people who are at risk of homelessness first, who have even a lower medium income than those people with 80% of the income. So we don't know if and under what circumstances you will be placed in line before the funds are exhausted. The only thing I can tell you is apply, get your tenants to apply, and coordinate it so you have a chance of recouping the funds in this capacity. And I also want to mention, the laws are fluid. The rules are changing. It's like quicksand. Every time I give advice or I put on a seminar, I've got to tweak the slides because they're changing. What I can only tell you is this is the information I have available. Stay tuned, but make sure if you do have a question or you do have a concern about a program, email me. If I can help you, I will. But I'm in the same situation as you. It's a new program. The protocol is through the websites. And if you're not tech savvy and you can't upload a document, find someone who can help you upload documents, because that's going to be necessary for you to complete your application. Let's move on. Evictions. So I've spent quite a bit of time talking about state rent relief under SB-81, but what I have 91, excuse me. I also have to address evictions. So normally pre-pandemic, if a tenant did not pay the rent, you could serve a 3-day notice to pay rent or quit. And if they did not pay that demand in 3 days, you would have perfected your right to file an unlawful detainer action or an eviction action in state court. Now, under the new rules, the tenant has a 15-day notice, not a 3-day notice. You have to attach a hardship document to the 15-day notice. If the tenant completes the hardship document and pays 25% of that debt by the end of June, you will not be able to evict them for non-payment of rent. You will not be able to evict them for non-payment of rent. The goal of this law is to stabilize housing during a pandemic. We don't want people to lose housing even if they can't pay the rent. And now we have the state rent relief program that will help people recover the rent debt. So for all intents and purposes, of course you can serve a 15-day notice, but likely the tenant is going to complete the hardship document, and then they'll have until June to actually pay 25 cents on the dollar. And hopefully before that time, all of you have actually submitted a request for state rent relief, and the funds are coming from the state. And as I mentioned before, if the funds are coming from the state and you are participating in that program, you lose 20% of that rent debt, and you cannot evict because you must promise the state that you're not evicting that tenant for that rent debt. Another component of this new law is that just cause eviction rules have been extended to all tenants throughout California, even those tenants who were exempt from the state just cause eviction rules. For instance, single family homes and condominium units generally are exempt from state just cause eviction rules, but not right now because of SB-91. So if you have a tenant on a fixed term lease that ends May 31st in a condo and you want the tenant to leave, you can't tell them they have to leave because the lease is up. Why? SB-91. The moratorium is over as of June 30th. The protections dissipate after that date. So those rules will change. However, I told you the protections may be extended. Stay tuned. We don't know what Sacramento is going to do. My guesstimate is that it will be extended through September. We don't know. Things are fluid. Most importantly, for all of you folks who are participating, your best bet is to avoid the court right now. The optics of trying to evict people right now is not attractive during the pandemic. And two, the courts are slow, if not closed, to non-payment of rent cases. So all things being equal, focus on recovery rent debt, not pursuing any claims in state court or county court. Let's move on. So what happens if a tenant, and I'll give you the example before, the tenant owes you $10,000 in unpaid rent debt through the end of June. At the end of June, they pay you $2,500. They paid you 25% of the rent debt. They didn't qualify for the state program because their median income is too high. So that you're left with $7,500 of rent debt. Under SB-91, you are entitled to recoup the rent debt through small claims court beginning August 1st. So if you are holding $7,500 of rent debt from March through June, you have to wait until August 1st to file the claim in small claims court. Got it? So the idea is, if a tenant has not qualified for state rent relief, filed a hardship saying they have had an impact because of COVID and paid you 25% of the rent debt, well, you're not going to evict them for that rent debt. What you're going to do is take that $7,500 and go to small claims court. And interestingly, yesterday I had a meeting with a client. Tenant owes them $65,000 in unpaid rent. I've been practicing law for 26 years. Normally people will call me and say, Mr. Bornstein, someone owes me $6,000, someone owes me $3,000, someone owes me $8,000. Every once in a while, pre-pandemic, someone will say, Mr. Bornstein, someone owes me $15,000, $18,000. I'll say, where have you been? You got 5 months of unpaid rent? Where have you been sleeping? Now people are calling me, they got $25,000 of unpaid rent debt. The rent is $4,500 a month and the tenant stopped paying in March and it's now 10 months, it's $45,000. The amounts are staggering. If you can get it from the state, great. But if the tenant by the end of June gives you on $40,000, gives you $15,000, they owe you $35,000, right? If they owe you, I'm sorry, they owe you $25,000, 15 on 40. If they owe you $25,000, you can go in August to go to small claims court to recoup that $25,000 in small claims court. The one thing I will say is when I use the word recoup, that's a misnomer. You can get a judgment against the tenant for $25,000. Collecting the judgment is going to be another thing. Also, small claims is normally $10,000. It's now been enlarged to no limit for a COVID rent debt, so that $25,000 can be going to small claims court. However, I will say this. I'm comfortable recommending clients go to small claims court for a $10,000 debt, but when you're at $25,000, you may want to consider hiring an attorney and going into regular court and filing a breach of contract action in regular court. You have much more control over the process. Small claims is a bit of a kangaroo court. You may get a volunteer attorney handling the matter, and they may come back and you may be surprised and not like the result. A tenant can still assert defenses such as a warranty of habitability or some sort of defense to the demand. So be smart. Small claims court may be very prudent for smaller debts, but larger debts, you may want to hire an attorney to go to the regular court. So that's the talk on small claims. Let's move on. I want to mention that I have told you about 3 minutes ago to stay away from the courts. Why? Because the courts have all different rules right now. Some courts are closed to eviction processes. For instance, Alameda County right now has an eviction moratorium that only public safety and health type of cases are going to be allowed to be filed in Alameda court. Before I can file an eviction action, I have to have an application to court to say this is a health and safety matter. For instance, vandalism, arson, violence, drug dealing. You've got something like that, you can proceed with your eviction. Non-payment of rent evictions, not interesting. Owner move-in evictions, not interesting. Nuisance eviction where a tenant's playing music at night, not interesting. You won't be able to proceed. Contra Costa County has a moratorium as well. San Francisco closed, but for serious evictions. So stay away from the court until the court figures itself out. For instance, Marin, you submit a lawsuit to Marin, and in the past, it would take me about an hour to get the lawsuit back from the court. Now it's 2 weeks. You're dropping stuff off at the court. Stay away from legal actions if you can, because the court is not operating effectively. There are individual moratoriums, and I want to emphasize that if any of you or your clients are contemplating legal action, talk to me first. I will tell you whether it's viable or not. And that's why reaching compromise with your tenants makes most sense. And if it's dealing with the debt, once again, as I've emphasized probably 15 times, state rent relief first, then see if you get it. If you don't get it, contact me about the rent debt. But for now, absent real serious misconduct in your rental units, stay away from filing eviction actions. Interestingly, not only is it difficult to get through the court, sheriffs, once they get a judgment and an order to evict, are sitting on those evictions because of the politics of displacement during the pandemic. So all things being equal, I've got 13 or 14 clients who have judgments waiting for evictions from the different sheriffs, and they're not evicting right now because of the pandemic. The only evictions that are going to occur are those that pose health and safety issues for the community. With all that stated, we are in a mess. It's a bureaucratic nightmare. And the only thing I can hope for all of us is that the pandemic dissipates. we get our vaccinations, and the light at the end of the tunnel is closely at hand. And my hope is that by September, by December, we're back operating in a much better protocol, more consistent with pre-pandemic government affairs, including the courts, the sheriffs, and tenants are back paying the rent that they owe. Let's move on. So normally, if a tenant's not paying rent, I would tell you, hey, you can spend money going to court, and it may be prudent to proceed with an eviction for non-payment of rent. Or you can negotiate a deal where a tenant voluntarily gives up possession in exchange for compensation. Right now, I'm recommending first try to get state rent relief. And if you can get rent relief, pocket the money. And then if the tenant continues to not pay you the rent, you may want to say to them, look, I'll be willing to waive that debt for April, May, June, July, in exchange for you voluntarily giving up possession of the premises. My office is doing buyout agreements throughout the Bay Area in different jurisdictions all the time. Be advised, different jurisdictions have different rules regarding buyout agreements. I'm happy to counsel you on it, but most importantly, voluntary move-outs are attractive if that vacancy is attractive for you. Right now, though, I would rather get that state rent relief than get a vacancy, because vacancies at this point in time with downward pressure on rents and also difficulty placing tenants may precipitate a better choice of sitting and waiting until you get that state rent money. I'm happy to counsel you on it. I do want you to know, though, that if you had to choose between going to court to seek the removal of someone or proceeding with a voluntary agreement for a tenant to transition in exchange for a small payment or the waiver of rent money, absolutely, I recommend a voluntary agreement. It's fast, it's easy, it's efficient. My office is here to do that all the time. I don't know of any law firm in the Bay Area doing more buyout agreements than mine. I have an attorney dedicated to just drafting up these agreements throughout the Bay Area, and it's efficient. And especially if someone you know is relocating to New York, but they're not going to relocate without some sort of rent waiver or some sort of payment, contact me. It makes sense to do it so you can free up that unit and get a good cash flow out of that unit so that you can actually start paying your debts as well. So with that stated, please, the law is fluid at this point in time. I can't tell you how many iterations of the law has accrued. I've never been tasked with more learning, because Oakland will have a new rule, Berkeley will have a new rule, San Francisco will have a new rule, the state will come out with an amendment to a law. San Francisco's eviction moratorium emergency ordinance is now on its 13th amendment from the mayor. And all I can tell you is I'm happy to provide you the information. You've got to connect with me through social media or email blast. It's my pleasure and privilege to educate you folks when a group like the industry trade group that you're affiliated with invites me to come and give a lecture. It's a privilege. Thank you for the opportunity. Again, this PowerPoint slide can be delivered to all of you. You can disseminate it. If you need that COVID documentation notice that was supposed to be issued in February, email me. I'm available to help should the need arise. And otherwise, thank you very much for your attention. And thank you for the invitation. And now if you do have questions, I'm available to answer as they come in.
Sure.
Okay.
So go ahead, Eric.
I was going to say, Daniel, thank you for the wealth of information. A lot of people have been commenting that the information that you just shared is awesome. There are a couple of questions that came up. I'm going to read them and try to interpret them. This is from an anonymous attendee. So they are asking, what happens with tenants who didn't pay for months due to the COVID pandemic, but then abandoned the property? I know that it requires both tenant and landlord to make an application. What remedies does a landlord have when the tenant abandoned the property?
Very good question. I get that question intermittently. The state rent relief program anticipates in possession tenants. The idea is we're trying to keep people in units so they're not displaced. If the tenant is not in occupancy and has given up occupancy, they owe you the money. You're not getting it from the state at this point. You're welcome to go to small claims court. You're welcome to hire me to file a breach of contract action, but you cannot anticipate the state coming and providing you payment, because in exchange for the payment, you're promising that you will not evict the tenant and the tenant is not leaving. So unfortunately, you're left with a vacancy and a debt, and you could proceed with a demand through the courts.
Got it. All right, thank you. Similar question. They're asking, do you mean that both tenant and landlord need to apply separately, or one side starts the process first and then the other joins? I know you covered that, but they're asking if
No, it's a very good question. Basically, there is a merger of the application so that the state is going to turn around, or the local jurisdiction is going to turn around, and based upon the address of the unit, meet those applications together. A landlord can initiate the application, but then the tenant is going to have to provide documentation substantiating the criteria and also the debt, and then it becomes one payment to the landlord. If a landlord is not participating in the program, a tenant can initiate the participation. And in that situation, with no landlord participation, the tenant will get up to 25% of that debt.
Okay, thank you. So here's an interesting question. It says, so what if a landlord and tenant have been in good standing? The landlord now decides to sell their property. The tenant has never missed the payment, but does not want to move because they can't find a home that fits their needs. Does the tenant have any rights, given that they haven't missed any payments? So that, yeah, the question, does it have any rights if the landlord is selling the property?
Yeah, so right now in California, because state just cause evictions have been extended to all tenants, tenant has the right to remain in possession of that unit, even though the property is being sold. And in jurisdictions that have just cause eviction rules, a tenant's right to remain in possession is paramount until a proper termination notice is provided. And the desire to sell a unit vacant is not a just cause under state rent control or local rent control to evict.
Okay. Here's another question, and I'm going to try to interpret what the attendee asked. So if the tenant volunteers to move out, can the landlord keep the security deposit if that tenant has both arrears on rent and utility?
The answer is yes, if the tenant is vacating. SB-91, yeah, SB-91, interestingly, has additional nuances to it, and that you're not allowed to take security deposit for COVID-related rent debt right now. However, that presumes the tenant remains in possession of the unit. If the tenant moves out owing you rent, you're perfectly entitled to subtract that from the security deposit.
Okay. Going back to one of the first pieces that you shared, it's great to hear that, you know, owners can possibly get 100% of unpaid rent versus 80. Do you anticipate that the application process for that will be the same as the current application process in place to recoup the 80% payout?
I do. I think they set up this protocol. They have the infrastructure set up. It's not ideal. In a prior podcast, I gave the program thus far a C+, and I gave it a C+ because I was disappointed that it's taken so long for the actual application process to find its way through their bureaucracy, and owners are still left without recovering rent debt from last year. I presume that since the protocol and the infrastructure is set up, that supplement of 100% is going to be through that same program. How do they do it? It remains to be seen. It may be logistically a long delay before owners are actually recouping that rent debt. So rent debt that accrued in March of 2020 may not be payable until the fall of this year. And that's going to be tough for people because people need the funds right now. It's not just tenants who are suffering. There are many, many other people suffering in the community, and it has less to do with their status as landlord and tenants, and it has more to do with what are the debts they actually are obligated to pay.
Okay. Now you shared a great flow chart on how the process worked, whether it's initiated by both either the tenant or the landlord. And then you also mentioned that some funds have already been paid out, although they've been minuscule compared to the amount of money that's out there to compensate owners. What is the timing? Do you have an idea what the timing is like from when either a landlord or a tenant starts the application process to when funds are distributed?
That's the big question. There is no clarity right now.
Okay.
There is no clarity, and that's what's so disappointing. We would have thought that if you completed the application and all the boxes were checked and the criteria was met, you'd get the payment issued. It's not happening. Now, here's a nuance, right? So we are aware that in California, unemployment compensation was horrifically subject to all sorts of malfeasant behavior, and that millions of dollars was taken through scams. I think that because there's billions of dollars available through this rent relief program, they're being extra cautious in doing their due diligence to make sure that people who are entitled to these funds are actually entitled to the funds, and there are no other scams that are going to create a situation where funds are actually taken out of the program that are not warranted. So I think that due diligence is part of the problem, and that's why there's such a delay occurring.
Got it. This is a question regarding eviction. So with respect to eviction, for tenants who did not return a declaration of hardship and did not pay the owner the 25% of monthly rent, so are not protected from eviction, does the landlord then follow the standard eviction process to get that tenant out?
In theory, absolutely yes. So if you serve a 15-day notice and you attach the hardship, and the tenant does not pay any money and does not complete the hardship, then you have perfected your right to file an eviction action. However, in certain jurisdictions, they're not accepting non-payment of rent cases because Alameda County has an eviction moratorium. So it's very cumbersome to see whether you're going to be entitled to evict for non-payment at this point in time. And more likely, 95% of the people who are being served that 15-day notice are filling out that hardship doc that's attached to it. And once they fill out that hardship doc, you're waiting until the end of June to see if they've come up with the 25% payment.
Okay. Here's a question that just popped up on the Q&A. It's asking if tenant is currently paying the rent now, should the landlord still apply for the state application for near future if the tenant will miss the payment? So it's kind of a what if.
Right. So the presumption is that there's a current debt owed when you apply for the program. So you're not entitled to apply for the program if you don't have a debt that's owed.
Okay. So with respect to the recovery of unpaid rent using the civil court, you mentioned that it's no longer a $10,000 limit, basically limitless. So if a landlord prevails against a tenant and is awarded a judgment, at the end of the day, you mentioned that the next challenge is actually, getting a payment based on the judgment. So if a tenant declared bankruptcy, they could just wipe that out?
Likely, yes.
Okay.
You may be standing in line. Also, it's one thing to get a judgment. It's another thing to collect it. And then if you got a judgment and then you hired a debt collection company to enforce the judgment, they typically take 40 cents to 60 cents of whatever they recover.
On the dollar, okay.
Yeah, so that's why if you follow this thing through, if you're hiring an attorney to go forward with a debt, you may be paying for an attorney, then you get a judgment, then you try to collect the judgment. By the time you're done with all the time, energy, and aggravation, you would have been much better off just going through the state rent registry relief program and get 80 cents on the dollar. The problem is there's going to be people who do not qualify for the program or do not participate in the program, and you're left with large debt. And what are you going to do? If it's
Okay.
$5,000, maybe you move on. If it's $50,000, you go after it, you hire an attorney. And remember, if you get a judgment, you file an abstract of judgment in that county in which the person resides. And every once, it's renewable for 10 more years. There's interest generated on that judgment, 10% a year. And so you could end up being very patient with this judgment. And every probably 3 months in my practice, I get a person who I have a client get a judgment on, call me up and say, hey, I'm applying for a loan. I need to clear this judgment before I can qualify for the loan. I'm ready to pay it. So I would not have you ignore it. You just have to decide whether it's worth your time and aggravation to chase debt. And it depends upon how large it is. And it also depends upon what type of tenant we are talking about. Are they wealthy, empowered, likely to have a strong economic background? Or are we dealing with a situation where unfortunately the person is judgment proof because they have a litany of bad debt, bad credit, and you're likely to be 20th in line for a collection?
All right, good advice. Here's a couple of that questions that just popped in. One is,
When can a landlord increase rent or start increasing rent?
You can do so now.
okay,
You can do so now. I will tell you this. The decision to increase rents during the pandemic is a case-by-case situation. Previously, there was a moratorium on it. But if you increase rents, remember the optics of raising rent at this point in time is not ideal. So that I would really think twice before I would raise the rent, because the accrued benefit of raising the rent now as opposed to waiting a few months may be such that you would have preferred not to raise the rent during a pandemic.
okay, good advice. Here's a question from, sounds like a real estate broker. So they are representing the seller. Looks like the transaction is about to close. One of the tenant has debt for rent due. How should they handle the security deposit on escrow for credit to buyer?
Very good question. Well, we know right now as it stands, you're not allowed to deduct COVID rent debt from the security deposit. So if I am the seller, I don't have the ability to deduct that security deposit from the rent. And so the seller has a particular issue. The seller has money owed to it from the tenant, but you can't easily take it from the security deposit. So I would transfer the full security deposit to the buyer and keep the debt that I can pursue against the tenant at a later date.
Got it. So with respect to noticing the tenants by that February 28th, 2021 date, which is passed in order to preserve the landlord's right to enforce collection, what happens if if the landlord did not do that or provided notice after February? So basically, if they didn't do that, your recommendation is just file it anyway, even if it's late, right?
Serve it anyways, even though it's late. And the only thing I can tell you is that the statute is silent as to what happens if you didn't do it. That's the problem.
Okay, so that's a to be determined as this process out.
Yeah, so let's assume that you did not serve it properly or you failed to serve it. Are you going to be entitled to pursue an eviction for non-payment of rent on that COVID debt after June 30th? Because you did not inform the tenants of their rights to participate in the state rent relief program or their rights to assert a hardship. It remains to be seen. I assume that tenant attorneys will be looking to see whether that notification was been provided, but we don't know how a judge is going to rule on this because it hasn't arisen at this time.
Okay, all right. Thank you, Daniel. So Justin, I think that exhausts our questions at this time. So I'll hand the mic back to you, so to speak.
Yeah, no, I think that Daniel did an excellent job in pertaining to SB-91. Covered everyone's questions. Once again, guys, if you have any other further questions, let us know. But I think we covered it. Mark Kim from ACP. Anything else to note? Anything else we're missing?
Oh, I learned a lot, and sounds like you're a great resource, Daniel, in this challenging time where things are constantly changing. So thank you for that.
It's my pleasure to participate. It's, like I said, a privilege. And if you want to welcome me back, I'm happy to come back. I will tell you, the laws are changing, and what I've spoken of today may be different than September. So please keep informed. And again, thank you for the invitation to speak to your client and your members.
Sure.
Yeah, we may have a follow-on webinar in early fall or late summer. So thank you, Daniel.
It's my pleasure. Thank you for the invitation again.
And just to sum it up, today's recording is being recorded. It's on Facebook Live right now. Tell our attendees and to all those that registered that couldn't make the entire presentation, we will have it recorded. I'll have it sent out as a follow-up. Outside of that, the only thing else I really want to give a shout out to is Eric Relos. Not only is Eric Relos a big part of ARIA, also with FARIPA, but yesterday was his birthday. So I just want to give you a
Hey, happy birthday, Eric.
happy
Working
birthday.
day. Thank you.
All right. So outside of that, Eric, Mark, Daniel, anything else? But I'm ready to go. I appreciate your time, Daniel.
Yeah, my pleasure.
All right.
Thank you very much.
Thank you all.
Be safe, everyone.
All right.
Thanks, everyone.
Take care, guys. Okay.
All right. Bye-bye.